Video's going. All right. So good evening, everyone. It being 7 o'clock, I'll call to order the July 5th, 2016 Housing Standards Board meeting. As we discussed at our last meeting, I've compiled an ordinance for us to get started with, representing some of the things we've discussed. And as we also agreed last time, our agenda basically consists of reviewing this and starting to add, subtract, revise, whatever. So we've got it up here on we've got a laptop projector and screen. So we pulled the ordinance up. There were some grammatical errors that I've already sorted through, but haven't changed anything other than that. I should also mention there are five regular members in attendance, and obviously 2 members absent. We have no alternates here, and as of now, we have no members of the public. So I guess we'll get started. I guess I'll just put out the question, open question to all of you. What do you guys think? Are we moving in the right direction?
I think so.
Okay, good.
I think it's a
The
good
fact we have
foundation.
something
And
to
high five.
actually, look at and read and touch, that's pretty good.
Yeah. Good.
And then would we make like a checklist for afterwards or no?
Yeah, I think so.
Plan.
Yeah, and I didn't, after listening to the tape again of last meeting, I didn't really feel like I had maybe, I don't know, enough sense of how the whole group felt where we wanted to go with the checklist. So my thought was to just add another checklist from another community, but then I thought, why do that? Why not just leave it blank for now? And,
Yeah.
but I think we talked about Belmont having a good one. I feel like I recall that from the tape. So yeah, that would be the plan, that there would, based on what we were talking about last time, that there would be a checklist to accompany this. Someone had said, let's not call it a checklist, let's call it a guide. I can't remember who that was, but, so checklist
A
guide.
checklist kind of
Yeah,
implies that
yeah.
as long as they have all of these, then they're fine. But
Okay.
a guide implies, yes, these, but could include other
Okay,
things as well.
right,
which
all
I think
right.
is good.
I think that's true, yeah. It makes it more clear that it's not part of the ordinance, it's just a user permit. Or maybe it is part of it, I don't know. Another thing we talked about, I think, I tried to follow pretty closely the basic elements: purpose, authority, applicability. And I put in the requirement that folks register, set some basic, set a basic inspection schedule with the statement, however, periodic inspections may be conducted at any time as deemed necessary by the Board of Selectmen. And you'll see throughout it says, or its designated agents in response to complaints, observations, or other concerns. My feeling, the reason I use that terminology, Board of Selectmen or its designated agents, I guess maybe it's obvious, but it really is, in my mind, in the authority of the Board of Selectmen and they have the right to assign the responsibility to these folks. I don't know, does that make sense? Okay.
Daria, I think I just, when I reviewed it, I think the bullets are definitely achieve everything that we're trying for. Do you think it'd be in our best interest maybe to review each one?
Sure.
If that makes sense.
Okay.
And maybe
Yeah, I
add,
think so.
subtract, or
Yeah. Okay.
or go from there.
All right. So we'll start with purpose. I'll just read it, I guess, just since
Yeah.
it's
Any
short.
comments on it?
So purpose: the establishment of a rental housing standards. Maybe that should be the establishment of rental housing standards, not a rental.
Is it rent? Okay, this one says
Yeah.
rental housing. Okay, Because we did talk about it being residential or not residential.
Oh, okay.
Housing would imply residential, I think.
This purpose says rental though, which I think is appropriate.
Okay, yeah, and residential, I think it, we'll have to see as we read, let's make sure it's clear that it's residential we're talking about. I think housing implies that, but maybe we need to make sure it's there.
Well,
I think
we
there
need
might
to
be
add
people
it to
that might want that.
applicability.
I mean, I think it's clear to a lot of people.
Well,
Yeah.
Some people need it.
as it goes
Really?
down, it says applicability, and it goes
Right.
into
Mhm.
where it where it's.
Yeah, right, but we should,
Yeah, let's
right, nonetheless, we should keep an eye on that and make sure it's clear that it's residential. So, sorry, let me start again. The establishment of rental housing standards and a periodic rental housing inspection program is necessary to protect the public health, safety, and welfare by ensuring the proper maintenance of such housing, by identifying and requiring correction of substandard housing conditions, and by preventing conditions of deterioration and blight that could adversely affect quality of life. In this pursuit, the purpose of this ordinance shall be to ensure rental housing complies with RSA 48A14, all applicable building and life safety codes, and the Tilton zoning ordinance. Good?
I might just give it a blight.
Okay.
I think there's gonna be a
We're trying
lot
to just
of
make it as user friendly
people, yeah.
Okay.
as possible.
Excellent. And it's, yeah, it's right, it's somewhat subjective and maybe even a little snobby.
Is there a way we can make it also too, so that, because I feel like a lot of landlords are coming into it with a pre-existing, like, oh, you know, this is just to make my life harder kind of thing. So they might read this and go, because they're already going into it as that way, maybe put something that makes it clear that it's for both parties
That's a good point.
somehow. I don't know how we're gonna word it, but imply that
It's a
it's
good-
for both parties.
Okay.
'Cause I just think that there's just so many landlords that are
I
like
think so,
all up in
too.
arms, just automatically without even reading anything. So,
Well, I think they got soured on it
yeah,
before
Yeah.
when it was
So
so
if-
lengthy.
yeah.
If we said something like where it goes, you know, by identifying and requiring correction of substandard housing conditions or preventing conditions of deterioration that could adversely affect quality of life. Furthermore, something like it is important that owners of rental housing be the words aren't going to come to me, but basically it's to say that, you know, this is to protect the owners too, because it's making clear that to everyone that this is how the housing is supposed to be maintained. I don't know. I'll put, I guess, because I'm not coming up with any wording.
Do you want me
Maybe
to
something we
spurt
can
something
send.
off?
Oh yeah, definitely.
Let's see, the establishment of an informational guideline for owners and renters detailing housing standards.
All right, so I got the establishment of an informational guideline. What did you say after that?
I forgot already.
How about after saying, I have to protect the public health, safety, and welfare of both landlords as well as tenants, comma, by ensuring the proper maintenance
Ooh.
of.
Okay.
Yeah, I think that's sentence, but yeah,
Mhm.
that's a very good point.
Landlords and tenants.
Okay. The establishment of rental housing standards and a periodic rental housing inspection program. I guess it should be R because it's two things here. R. Oh, I have it on.
You took off the insert.
There we go. R. Necessary. Yeah, great. What did I take away? Yeah.
Here, you
By
wanna look at
ensuring the
this and
proper-
see what you took away?
By ensuring the proper, in between there.
Okay, thank you. Okay, protect the safety and welfare of landlords and tenants.
From,
Identifying requiring correction of, how about of any substandard housing condition,
Okay.
or, I don't know.
I
I mean, it's saying the
fine
same
with it.
thing.
Yeah. The,
I'm
You
wondering,
don't want to put any substandard housing because it, of substandard in itself is any.
Right.
So it would be
It's
of
not.
substandard housing conditions, and by preventing conditions of deterioration, I would kind of leave that.
Mhm.
does this do anything to make it easier for landlords to evict their tenants if they don't maintain their responsibility?
No.
It might help, like, if they go through the eviction
Like-
process in court, they could probably bring this up and point it out to, say, the judge, and it could influence the judge's
I'm thinking
decision,
of like bags
then
and
it's
bags
illegal.
of garbage in particular.
No,
'Cause
because
some people kind of have collections of garbage. I don't know if
I
they do
think they
here, but
can
I've been
if
to
it's
houses that
breaking
do.
a
if we
housing law.
propose a health issue and it goes before and we get if we get clearance from the judge to clean that health issue, so let's say you remove them temporarily to clean that health issue, and the tenants and the landlord say, well, that's it, I'm gonna evict you anyway. It doesn't hold up in court. So they still have to go through their process.
I just wondered if we were
Making
doing
sure
something
that-
that would impact.
I don't, it doesn't, because what we're doing is for health and safety in substandard conditions. It's not about a landlord-tenant. So it's strictly for health and welfare.
Okay, thank you.
So that would be my opinion on that. I think we've had a few cases that we've looked at, and it's, the owners really would love to, evict them on their end, but they're not able to.
Yeah.
And they would like us to step in and say, oh no, come on, help us, but we can't,
Right.
because it's not our position.
Right.
We're only there for the health and well-being of
Mhm.
the unit, so, the substandard conditions, I
Right.
should say, so. I don't really think that it would, unless we're missing something that we haven't, in those couple of cases that we had, but for the most part, I think that it would not affect their chances of being evicted, or the opposite.
Jenny, do you feel as though that adding the owners and tenants helps? Is that enough? Maybe or should we just keep looking for opportunities to make sure that it's the wording throughout the ordinance doesn't appear to be sort of
Well, I think
favoring one or the other?
we gotta go through it and kind of
Yeah.
really read it and listen to it and just kind of get a sense of, is this gonna feel one-sided in this
Okay.
sentence? It's gonna, just
Yeah,
gonna
yeah, all right.
feel them out as they go.
All right. So should we move on, or should we keep going with purpose?
I had one other thing.
Okay.
On purpose. Obviously, the majority of this document is focusing on the health side of things, but you also list all applicable building and life safety codes in Tilton zoning ordinance. So,
I trained in Belmont,
Yeah.
signal 21, state.
I didn't know if you thought it'd be appropriate. I mean, the town of Tilton enforces the New Hampshire State Building Code. The fire department, everything under life safety comes underneath New Hampshire State Fire Code. I didn't know if we're listing RSAs, would that be appropriate, or would it just be, I'm good with general either, I just trying to be consistent.
Yeah, to me, my thought is general is safer in terms of making sure the ordinance never falls out, or falls out of date less frequently, or you have to revise it, but that's the only reason. I was originally thinking of putting, I think, one of them lists, it even says 2009 building codes,
Right.
electrical code, plumbing code.
But you're saying to put it as fire safety code, or is it the
Well,
life safety code?
It's, well, so, everything that we have in the fire district is adopted off the state fire code. That lists everything that we enforce, which is the NFPA.
Yep.
So I know you have RSA 48.
Which is our thing, yeah.
And everything in the fire is 35, I believe. And I'm not sure what the buildings, Al would be able to tell you what side the building is. I'm not exactly sure. It might even be the same thing. So I didn't know, I'm good with having it be just like that, but I didn't know if we wanted to put that verbiage in there as well.
So what if you put building, comma, life and fire safety codes?
Well,
Now
I
you're
think,
covering
Can you,
everything.
can you capitalize it to imply?
I'm good with
that
that,
it's
how it is right
actual
here. I
code?
don't have a problem with it. I just know
I'm gonna-
the
yeah.
consistency would have been.
I think we should leave it the way it is because I think our conversations to this point have, made clear that a lot of this stuff is already existing. Without this ordinance, this stuff would still exist.
Sure.
And I feel like that implies that.
Okay.
We're saying all that stuff okay.
Could we put the word existing in front of RSA?
Oh, like all
Um,
present
All
existing.
applies
All
with
existing
all
applicable building
existing
safety
new-
codes.
I think applicable is a better word
Yeah, I agree.
because
But just add it to it.
Yeah, because
all
if you put the word
existing
existing means
applicable.
present,
Mm-hmm.
and it's whatever is present, and that code, the RSA itself could change. So if you
That's
put
true.
New Hampshire
Oh,
RSA,
Yeah, yeah,
then
you're right.
and it doesn't, no matter what it changes to, it's still gonna be that RSA. But if you say existing, then it could,
Mhm.
now if this comes out in 2016, they're gonna go back and say, well, it says existing in 2016, so they're gonna always go back to
Yeah.
2016.
Yeah.
somebody will
Yeah.
I'm gonna miss
Yeah,
this one.
like I said,
Yeah.
I'm good with how it's written.
All
I
right.
just was wondering for consistency
Yeah.
purposes, we have one RSA listed and then we just have verbiage describing the rest, so.
However, you did make me realize I didn't put the word health in here. Maybe it should say all applicable building health and
Mhm.
life safety
Mhm.
codes. So
That's what I was trying to get to when I said the fire, because Catherine relies a lot on the fire. That should be health.
Mhm. My
Okay.
biggest concern is that people thought at the town meeting, from what I could gather, that whatever we come up with, they don't want it to mean that they have to go back and knock their buildings down and start from scratch.
Oh,
That's the one thing that I heard from people was, I don't have the money to do that,
Yeah.
and if I have to do that, I'm walking away from my mortgage.
Yep. 'Cause
And
was
I don't
just-
want to give the impression that that's what we're going to have them do, is if they're, because there's a lot of really old buildings in Tilton. And I don't know how many of them have knob and tube wiring, which probably needs to be replaced. I don't know how many have older pipes that aren't really up to today's codes. I don't know.
Yeah, I don't know. Yeah, all right. Well, let's keep
Well,
that.
you need to-
That's
you need to
another
read
thing.
I mean, that would be, that would be if an owner changes it, ownership changes,
Mm-hmm.
like Knob and Tune,
Yeah,
for example.
yeah.
Knob and Tune, when I purchased my home that I rented for 30 years, I couldn't move into the opposite side and the landlord side of it until I first got rid of the Knob and Tune.
Right,
Because it was in the codes, I knew that. And
yeah.
I was told that. So you an owner or a landlord already know the codes there and can't rent to somebody in a building that has knob and tube.
Right. Well, that was just an
Right.
example. I know that knob and tube is really not a cool thing,
No.
but you know what I'm saying? It's
Yeah.
like,
We can't prevent everybody from freaking out, you know? If they're
I
gonna freak
know.
out, they're gonna freak out.
there were a
so-
lot of people freaking out at town
Right, they were-
meeting.
I mean,
And there was
We're not
reason
even
for
reading
that
it.
too,
We're not even
because
It was
of the
62 pages,
right.
so
It
you
was
could read it.
exactly,
I wasn't there.
and if the height of the ceiling wasn't right, I mean, there was a reason for them to freak
Yeah,
out.
there
So
was.
we're giving them a reason
Yeah.
not to freak out. And there's a couple.
I just want to
pages.
make sure that
Yeah, true.
that
Anything we
we're
put in
aware
here is
of
gonna be
that.
better,
Maybe
so.
maybe it was a
People-
good thing that showed up. Well, yeah.
Yeah.
Well, we can't prevent, there's always gonna be people.
Oh,
that are gonna
yeah.
go, oh my God, like, it's gonna
there's
be
always going to
overwhelmed.
be somebody that doesn't like what we do.
Right.
At least.
We'll find that out in the first public hearing.
Just like being a
And the
selectman,
the thing that's tough is that, if you own a rental home or a multi-unit, it's a business. And because it's a business, you have to comply with the requirements to run that business. There's no difference. It's required by state law, so.
It's true.
We're not imposing anything that's not already
Yeah, right,
imposed.
exactly.
It's not
Right.
for me, it's not really a business if it's only one apartment.
Are you renting it out with a lease?
Yes, but it's not, they're telling me it's not. I have to do all the paperwork and all of that and taxes.
Oh, for the tax side, okay.
But you wouldn't be considered a business. You're a landlord trying to sustain your home. In other words, if I had more than one apartment, then I'm a business.
So if you live somewhere else and just was renting out both sides.
Exactly, and then it would be
But
a
it's-
business, right?
It's a revenue generating endeavor. I mean,
Right.
That's exactly, yeah, it's
Yeah.
clearly defined in all these documents what, a rental property is.
Yeah.
Oh,
And,
okay, yeah.
So, I didn't realize that about as far as the insurance and all that stuff and taxes go though, so I wasn't aware.
So far, that's what I've learned. And I said, that's fine with me, because I really don't want to be a business. So I figured, okay, I'll be filing as a business. Well, how do I file as a business? You know what I mean?
Sure.
Because it's not, but I don't, because I live in the same building and it's not a money-making kind of thing.
Mm-hmm.
In other words, if I had another one, then it would be profitable making.
Correct.
In other words,
Right.
this one is like a wash.
Gotcha.
Is it effect or should it say affect?
I think it's,
Where are you
A.
looking?
You're right, I think it was an
For which one?
A. No.
The effect is a motion.
It would adversely affect.
The
This is-
effect,
I think it's
and it
E.
would adversely
I'm thinking E
affect.
now.
You're right, it's effect.
With an E?
Yeah,
A.
A. Effect
Um,
has to be a part, like you used the word, the effect would be, but it does affect.
But there's a
something.
verb, effect.
We have a non-public motion that we do, that we say, non-public, that which would be discussed would adversely affect.
A, right?
I think it is. Nay. Got it right here. I
With
think it,
effect, you should have a,
I believe it is.
Are you saying there's no effect, effect
Yeah,
with an
there
E is
is.
never a verb?
no,
There is, but
oh.
it's not used in that.
I've been using it
I think this is the
If
time.
it's,
it's-
I've been
it
using it
is
a lot.
effective, no, that's
You-
not a verb either.
I feel like it could be either. It's affecting quality of life and it's affecting quality of life. How did I mean it when I wrote it? Actually, I just copied. You know what? I stole this from another town.
It's
It's gotta be
A.
right.
It's,
So-
no, it isn't. That means it's gotta be wrong. Which town was it? Pittsfield?
I don't know. I don't remember now.
I think it is an A.
I think it's an E.
I think it's an
What did you
Say
say,
A.
a what?
A. An E.
He
Well,
went
it's
right
two
down the
against
middle.
two.
Did too. I'm like,
Sounded kinda like a bit of an either.
That's my southern accent.
What we need is a dictionary.
The town I got it from had it as an E, I do believe, because I'm pretty sure I copied it. Pretty sure I copied and pasted it.
It's an adverse effect, but it does adversely affect.
Okay, I'm just saying, I think it's an E.
It is, I know it is.
Right,
What
according,
A-E-N-E?
according to Google, to affect with an A is something that causes change or influences change. An effect.
Yeah, right. If it was affect, it would say to adversely change quality of life. Here it's saying impact quality
Yeah,
of life.
so what I'm thinking of, what I was thinking of in the non-public motion that we make, it's written differently. It says, would likely affect adversely the reputation of any person. So that's, it's,
It would
Can I
affect
just-
affect
adversely.
would
If you're
be,
gonna put, yeah, if you're gonna say either adversely affect or affect adversely, or you could say that could cause an adverse effect.
Mhm.
Yeah.
But if you're gonna put it this way, it's
Well,
with an A.
let's do this. Let's,
Women unite, it's A.
yeah,
Yes, A. Against two, sorry.
no, we're gonna just put it as,
Dari's typing.
yeah, that's right.
Let's
Three.
hear it for a female intellect.
The, all right, here's what I'll do. I'll change it to an A to show my compromising nature, but I'm gonna leave it highlighted so that I
Okay,
can check it.
that's a good idea.
And I still, on record, I still think it's an
On record, it's A.
A. All right,
All right, we'll see what it is.
shall we move on to authority, or what else? Purpose looks,
I'm good.
okay for now? Okay.
Yeah,
So authority, basically, I'll read. The Tilton Board of Selectmen or its designated agent shall have the authority to enforce the provisions of this ordinance in accordance with New Hampshire RSA 48A.
that sounds fine.
All right. Applicability. The provisions of this ordinance shall apply to all rental units within the town of Tilton. Specifically for the purpose of this ordinance, rental units shall include any property which contains a suite of one or more rooms located within a single building rented by the owner to one or more individuals living in common for non-transient residential purposes.
You do
Non-transient
have
being-
residential there,
Okay.
because I was gonna say to add the word residential to all residential rental units, but you've got the residential part down in the second part.
All right, so we've knocked that one off. That's good.
Okay, I'm good with that.
And then specifically for the purposes of this ordinance, rental units shall not include dormitories, hotels, hostels, inns, bed and breakfasts, or continuing care facilities.
How about businesses?
It's
Commercial-
so
commercial
obvious
businesses.
Well, if you say
that-
residential,
No, because
then
they
it
do
says-
have commercial businesses for rentals, which would be included in this.
Would it? I thought we said residential.
Well, they have residential housing, which is a commercial business.
Oh, I see what you mean. Yeah,
So you may
yeah.
have management companies
Yeah,
that
yeah.
have residential housing.
Got it, got it.
So are we good?
Yeah.
Yeah.
Okay.
Should we put the word not in capitals?
This is my thought. We shouldn't do capitals or underlining or bold or italicizing because every word of this ordinance is of importance. And you see, I used to wonder. I used to work for the
Promote
state,
skimming,
and
probably.
I noticed that in the state RSA's they never bold and I feel like it's one of those things where you say this is important, you're somewhat saying the other things aren't.
Right.
But that's my thought on it. Just because I was thinking,
Yeah.
it crossed my mind. There were several times where I did, like, when I get to a shall not, I always want to like underline it or italicize it. But I said, no, that's not how ordinances are done.
Yeah.
But if we want to go that way, whatever.
No, I
I
think
think you're
it
right.
would promote people to skim.
Mm-hmm.
Mhm.
Right. Yeah.
and-
Yeah.
Yeah, I do too.
Okay.
Registration.
Registration. Every owner of a rental unit located within the town of Tilton shall place on file with the town clerk a separate rental registration affidavit for each rental unit within 30 days of the passage of this ordinance. Every owner of a new rental unit located within the town of Tilton which becomes available after the passage of this ordinance shall place on file with the town clerk a separate rental registration affidavit for each rental unit no later than 10 days prior to occupancy. The rental registration affidavit shall be made in a form provided by the town clerk. And then this is I went kind of on my own with this a little bit. A fee of $25 or other amount established by the Board of Selectmen shall be submitted with each rental registration affidavit.
Now, I do have a question about this. I don't believe, did you check to see whether it's the Board of Selectmen that sets the affidavit fee or it's the town clerk? I believe it's the town clerk.
Okay,
So I would
Alright.
just double check that.
all right.
And then whatever it is, then go accordingly.
Have they
Okay.
always charged a fee?
Up until, yes,
Yeah.
it's been mandated, 3 years ago, I believe it started with the landlord affidavits.
Well, wasn't
Okay.
Catherine saying something one day when we were getting hung up on the fees or whatever? And she said,
Like
don't worry about it because we selectmen can override you or whatever anyway?
Oh, yeah, we can do that, that's something different, yes,
Oh,
we
okay.
can do that. Further down, when you say no fees, we can override that if we want it on an ordinance. However,
This particular.
Oh.
this one is, this is a law that came into effect 2 or 3 years ago, where they have to claim that you're a landlord. You have to fill out an affidavit and say, I'm the landlord for 251 Main Street, I have 5 units, and here's my contact information. That way, if there was ever a fire or burglary at 251 Main Street, we have that information that we have, the purposes of that. In contact, because there have been several occasions, particularly down in the main streets or in the Main Street area, where we have out-of-state landlords
Right.
and sometimes bank-owned landlords. So it becomes very difficult to get in touch with who is in charge, because now we've got a ceiling that's ready to collapse because we have water leaking and nobody knows who we can get in touch with because nobody knows the landlord. Well, who do you make the checks out to? Miami Bank. All right, so then we call them Miami Bank, and it takes sometimes a day, 2, 3 days. 4 years ago, it was awful with this building next door. And we finally got in touch with a lot of it. And then this rule came out, and I believe it was state of New Hampshire rule that came out by the Secretary of State.
Yeah, I'm not familiar when it came out or who.
I think it was about 3 years ago, where you have to, if you're a landlord, if you become a landlord, you have to go to the town clerk's office and fill out the affidavit. Now, I believe that fee is up to the town clerk. I could be wrong, but I'm pretty certain that fee is up to the
And it's
clerk.
per unit, not per
No,
building?
it's not, it's per landlord. So you could,
See,
Okay.
okay, here, that,
look
interesting.
at,
Because
There's
this
a
kind of
couple-
implies it's per unit.
Well, it
Yes,
would be.
it does.
It would be, and that is because we're combining.
it's on the town
We're
hall.
essentially saying that because you're filling out your rent, because you're meeting the requirements of this ordinance, we're going to help you out, and for free, the $25 you pay for this is going to get you for free signed up with the town clerk. And additionally, there are some exceptions to that RSA, such as maybe if you live in the building and there are only 2 other units in that building, you don't have to fill out the landlord affidavit per state law. However, we want, for this ordinance, you do have to fill out the registration. So this is my thought, is that you gotta pay $25 per unit, or it essentially plays out this way. Sorry.
Sure, yeah.
You have to pay $25 per unit to get registered with the land use office, and in doing that, you're taking care of your registration with the town clerk for free, or, they're gonna waive that cost.
Okay. And what about the owner occupied unit?
Right,
that-
they have to sign up.
They still have to pay the $25 for that?
Well, what do you mean? Do you mean that's not really a rental unit, right? An owner occupied unit?
No, it's not, but
Or you mean?
they still
how-
have to meet the same codes and everything, don't they? The landlord occupied unit?
A house, you mean? Like someone who lives in their house?
If they have like a duplex?
Oh,
Yeah.
then no, you have to sign up, and,
Right, you
all
just
right,
have-
maybe we have to go back to the beginning of your first question. I was assuming you were asking, what if, like, somebody lives in the house that they own, and I was saying they don't have to do anything, they're not under this ordinance. But you were saying a building where the owner lives there, but there are also other rental units?
Yes.
Yeah, okay, so they have to, my thought would be, this is a good question. Okay, so if you lived in a building with 10 units in it, I guess the way this is written is that you have to file 10
No.
registrations.
So
Okay,
here's the
so then we need to
affidavit
change
itself.
it.
So here's the property owner
Right.
affidavit itself.
Yeah,
So it lists per RSA 540:1, the affidavit is required be filed with the city clerk. The owner, the date, rental property address.
So that's what I was gonna say, property, not unit. rental
Owner
property.
address, phone number, home, cell, work, email address, and please indicate which preference you want for contact. Designated respondent to accepted services name, so you're designating someone in the building to be your email address. Expiration of respondent status, and then a fee of $15, cash or check. And then it says, I, and then the person, swear and affirm that I've designated the above named so-and-so as my representative, having responsibility and authority to accept documentation and services for the rental property at the address listed on this affidavit, and then the owner's signature and justice of the peace notary. So this is, and then the clerk has a file number.
Mm-hmm.
This is on our website under the main page, and way at the bottom it will say landlord affidavit. Now, if you look at landlord affidavit on this one now, this is where it's conflicting, because it says, the following affidavit is required to be filed with the town clerk. There is a fee of $20 per affidavit. For more information, see the RSA definitions.
The thing is, okay, so I think we have to be careful not to think that we're this registration is going to fall right in line with that one, because again, we wanted to have that if you live in a building, let's say with two others, so you live in a building with 3 units in it, the owner lives in one of them, and there are tenants in the other 2 units. My understanding is what we've discussed so far, we want those to come under this ordinance. We want them to have to register. However, they wouldn't have to fill out, in accordance with the RSA 540 or whatever it was you said, they would not have to fill out the affidavit that we're currently using. So there's going to be a little, because that's one of the, if you look at it, does it continue on? May I? Sorry. Non-restricted property means all property rented for non-residential purposes, and the following real property rented for residential purposes, single-family houses, if the owner of such a house does not own more than 3 single-family houses at one time. So we don't want that exception to exist. Rental units in an owner-occupied building containing a total of 4 dwelling units or fewer. We do not want that exception to exist. And then, I don't know, the last one, I don't know, maybe we do, it doesn't matter. Single-family houses acquired by banks or other mortgagees through foreclosure. I feel like we don't want those exceptions to exist in this ordinance. So
We need to change this then,
okay,
because this, this is saying go ahead and do the affidavit.
when,
And if I were just a resident and just saying, okay, I want to apply by all the rules and regulations, I'm going to say, here's a housing standard ordinance that tells me that the rental rate registration affidavit shall be made in a form provided by the town clerk, a fee of $25. So you're saying this rental registration affidavit is different from the landlord affidavit?
yeah, I think what we do, my thought, and I don't know if we've talked about this in a meeting yet or not, what I was thinking through discussions I've had with folks would be that it would replace the form that's now, and we would generate a form that we give to the town clerk, and we say, or we could do it in the land use office. We could change this to say you register in the land use office. Maybe that would make it clearer. And it's, you know, part of my job is to transfer the information to Cindy to cover her end of it. But we would create a new form that covers the needs of both offices, both the town clerk and the land use office, in terms of allowing the land use office to help administer this ordinance. And so it would still be a form provided by the town clerk, but it would be a new one.
I think we're going to have some trouble there. Just my thought.
Okay,
Because we have
but
one sent down to us by the rules and regulations that are sent to her that she needs to fill out, have filled out, and she has a fee. That fee goes into town clerk, tax collector is collected by her.
The way that it sits though with those exceptions, it allows some housing to fall through the cracks.
I agree with you. I
So-
totally agree with you. I'm not at all adverse going with what Dari is saying. I think we need to tiptoe
Yeah.
with that because we still need to keep that existing one by law. So if we can work within the law in having the landlord affidavit and still incorporate it with our rental affidavit,
Maybe
then that would work out just fine.
But
the
if
law
not-
I'm not
accepts them
against
for
that.
paying, maybe, but maybe we say, okay, we can't go against the law and say, well, those exceptions don't exist, you have to pay. Maybe still require them to register, they can just not maybe have to pay the fee per the law, but we need to know who they are, where they are, and
Yeah.
they're still subject to the ordinance.
But also,
Does
there,
that kind of play on the?
sorry, I don't mean to
No,
interrupt.
it's
I think the charging, there's no problem with charging the fee, though. I don't think, right? I mean,
No,
even if
well,
it's above and beyond.
I don't think so, but I think where you would be really getting into I'm just envisioning, I'm just trying to look ahead and play the devil advocate here. Okay, so you're into town clerk tax collector authority, and then she's collecting a fee, and then for landlord affidavit, and then now we collect a fee for rental affidavit. Now, then, so are we really kind of double dipping on that and saying, I mean, I'm looking at the residents and saying, well, wait a minute, we're gonna pay a fee to rent, to fill out a landlord affidavit, and then come here. If we could contain the both of them and pay one fee, that would be perfect for the residents. But would it incorporate all our out-of-staters too? That's the main thing. We really need to cover that.
Oh, no, it would definitely cover out-of-staters. I think, you know, it's gonna be tricky, especially given what you said, that the town clerk is used to taking that money in
Right.
and feeding it into her own
Coffers,
budget.
Right,
Yeah.
exactly.
So that's something we do need to think about.
You just gotta figure out
Yeah.
where that's going and
Right,
how
right.
that passes through. Once we know that, it's easy to revamp this accordingly. That's not really gonna be a problem. We know what we want. We
Yeah.
want it, I think, we probably want just to have one landlord affidavit, which would cover our needs and their
Yeah.
needs at one time.
Yeah.
I would think that would be the best way
I
to do
think
it.
so too.
And then
No
have one
exceptions.
fee, and then just have one fee and
Mhm.
see where that fee goes.
Right, and maybe we can figure out, maybe if the fees, you know, let's say it's $35, and she's expecting $20 for each, you know, one of these that falls under her definition.
Yeah.
Now we're collecting, so we say from all the ones we get $35 that fall under hers, maybe there's a transfer of $20 to her department. Again, I don't think we can figure this out tonight, so. I
No,
won't
we're
go
not
too
gonna
long,
figure
but-
it out. No, we're not.
But, and then $15 stays with the land use office, and then the other ones that wouldn't have been required to go into the clerk, all $35 stays, when I say stays with the land use office, there's no such thing. Land use office obviously feeds all its money into the general fund, but maybe something like that.
Some of the fees from the town clerk tax collector goes into the general fund as well.
Okay.
So that's, I think that answer is gonna be from
Okay.
Joyce and Tim
Okay.
perspective.
All right,
And I think you'll get that.
okay, all right.
If
all
I
right.
were somebody reading this and I were a landlord, I would look at it and I'd say, oh, well, I'm already registered,
Yeah, right.
you know, because we went over that list last time, and there's a lot of people on it that will assume that they're already registered if we don't make it clear that what we
And I think
expect.
the people in the exemptions are gonna go, oh, well, I don't have to bother. And they won't register, and then they won't, you know what I mean? They won't think they're
So-
subject to
It's a
this.
good point.
Okay,
They won't
so
think they're subject to this.
all right, so there's work to be done on this, I guess is the answer. I think something like that, where you guys were talking about, you know, maybe there's just some outreach that needs to be done.
So a new ordinance, I know, sending out a new
Mhm.
ordinance with the checklist and so on and so forth, and now everyone has to renew their going out.
And we
reviewing
could
it,
put
whatever.
that in there, current landlords who are registered need to re-register or
Or
something.
maybe people could be, whatever, I don't wanna call it grandfather, but if you're, if you've done your due diligence and you've got your registration in, maybe they shouldn't have to come in again.
Yeah.
Would that, I mean, how,
Well,
are
I'm
these,
just
these aren't
thinking
an
the way
annual
people-
thing, are they? They're like a one-time thing.
Yeah.
Mhm.
So maybe we say, those of you who are already in, are in.
That would
And
make
we-
people a little more friendly
The
towards
main-
what we're doing.
The main purpose is to get them in to register, that's the
Right.
purpose.
Exactly.
So
Yeah,
if they're already registered, then we really don't wanna have to say, well, okay, for,
Well, and people would see that we're working hard to try and make it equitable.
Yeah. And then somehow get the word out, though, that those people that were exempt from registering, still, they need to register with this.
right,
You know,
exactly.
somehow get that
If
out.
you've not already
somehow.
registered or something like that.
So ultimately, it's the goal just to have the one registration form for both the
I would
tax
think
collector.
I
that
think
would be
that's a
our
really
goal,
good,
right?
good
You
goal.
think that that's our goal, right?
Mhm.
Yeah, I would
Mhm.
agree with that.
Yeah,
So
I
they're
would
not,
too.
they're not doing it twice.
I think it may be difficult from what we're working with. It may be a difficult process, having
Yeah,
a
you-
town clerk versus, because town clerk in all purpose and all, so that Jenny and Marion know, town clerk is its department and entity all of its own. We don't have control over that at all. Whatever fees and things that they set are set either by the Secretary of State or the Division of Motor Vehicles. It's not set by us. We don't have control over that. We don't have control over the hours, we don't have control over anything. So there's some things that we're not going to have control over, and that's what I guess what I'm stressing is that there may be some difficulty in trying to get that melded into one.
But if they have
If
all
there
the-
isn't, we're, it's a bonus.
If they're all in a file on the computer,
The information certainly can come to us.
yeah, that's
not
what I'm
an
saying,
issue.
we could
I
share
don't
the
think that that will-
information at least.
I don't think that that'll be an issue. I think going to we have to figure out where the law is
Mhm.
regarding town clerk and acceptance of landlord affidavits. I
But if the
think,
state says
Right.
$15, and we say $35 and there's a conflict.
right.
Yeah.
Well, maybe, unless we say $15 of it is meeting your this RSA,
Mhm.
and the other, what do we say, $20 is is going toward our housing standards ordinance. I don't know. And
Do you
so,
Yeah, break down the cost. and
Do you
Maybe.
say,
think that's
okay,
something
yeah,
we
we're
need
doing
to
for the
put in
state,
here, or?
yeah, maybe we
Kinda like
could even
state and
say,
town car registration.
if you fall into those exceptions that I was reading, your fee is such and such, which is subtracted the town clerk fee out. I don't know.
It's gotta be in some other document somewhere, I'm sure, because they're fall into the same guidelines, so.
we can probably get that tomorrow with
Yeah.
Cindy, I'm sure.
Yeah, right.
There's no sense
Yeah, it's
hashing it
not-
out
yeah,
right
if we
now
don't know
because
the
there's
answer.
a lot of unanswered
Right.
right here. We don't know how to
Yeah.
proceed beyond that. And that's probably pretty much what's holding the registration portion of this up is just that.
Yeah.
So one other thing that kinda got this ball rolling was the distinction between units and properties.
Yeah, I did. I made that change. Thank you.
Mhm.
Thank you. So I went ahead and changed, and let's see if this addresses what came up. Every owner of a rental unit located within the town of Tilton shall place on file with the town clerk a separate rental registration affidavit for each rental property. I changed it from unit to property. Now, we don't have that defined. In fact, we don't have definitions, so we may want to look at whether we need to define some terms here or not. But if, maybe I'll highlight this, and if we do define terms, I would
Yeah.
maybe say, I'll put here,
Should the first rental unit also be rental property?
I don't think so, but I'll take a look. We do want to have rental units identified somewhere. We're
No,
not changing
it's-
everything.
That's a single.
Definition of rental property, something about one building or something, right? I mean, what if you have a lot that has two buildings on it? Is that two rental properties, Tim? What do you think? Or is that
I would
one
think
rental
so.
property?
If you have, two. They have to have two different addresses. they're
Yeah.
separate buildings.
What if it's
We have,
basically separate buildings is
Separate buildings.
instead of
two
separate
rental
addresses,
property.
right.
Yeah.
Okay, all right.
It's the same management company, we have, like Hodges has 4.
So Main Street, you know, they're all connected, like when we walk 901, they're all separated by different addresses as well.
Hmm. So what should the definition, all right, is it one building, one owner? Because what about that? What if you have this massive stretch that, you know, because everything's touching, it could be considered one building, but it's, you know, an entire city block and there are 8 different owners. Those should be 8 different rental
Well-
properties, right?
You gotta kinda look at this, cause you have a duplex, I have 7 Maple Court and 9 Maple Court, it's 2 addresses, but they're connected, I mean, the same porch, you know,
I would
the
think-
buildings are
yeah,
connected,
the
there's no
address.
question. So, am I a landlord for two units, or am I a landlord for 1 unit? Cause I live in
Yeah,
one.
it's a good question.
So, you know what I'm saying?
Yeah.
So you have to think about that, and down here you have, let's say for instance Hodges, across from Riverfront, across from the Belt Factory, they have four buildings, Tim?
Yes.
So they have 4 separate addresses, but yet you can go down to the property on Deer Street, which has, what, 20 units in it? Or,
Yeah.
but it's one address.
Well, we can't go by property owners, one owner, because what if somebody owned a house here and then they owned another house 30 blocks away?
Well, no,
There's
we're
several.
not saying that.
We
I
have-
guess I'm saying,
We have landlords that own 5 and
Right,
6
right.
different pieces of property
right,
in
well, you-
town.
but okay, so I guess what I'm trying to say is I think definitely we're not gonna have a definition that says if you own 5 buildings around town, then those become one rental property. We definitely won't do that. I guess what I'm,
But right now, under the current landlord affidavit, they come in and say, here are my properties,
yeah,
and here's
Um,
my fee. And they list the properties that they own. I don't believe that they fill out a separate one for each one.
all right,
Maybe they do, I don't know.
all
I may
right.
be
Something
wrong.
to find out.
I
Yeah,
guess
we
my-
can find that out.
Yeah, my thought is that our minutes will now reflect sort of the gist of this. I've got a note written down, and my plan will be to sort of research different definitions of rental properties and
Got it.
find one, I think that meets what we've discussed.
Yep.
All right,
Okay, sounds good.
all right. Shall I move on to inspections? All right, inspections. Every owner of a, and this is a little bit longer, no, not too bad. Okay, inspections. Every owner of a rental unit located within the town of Tilton shall permit the town's periodic inspection of the structure in which the rental unit is located, following the receipt of a notice of inspection. The purpose of said inspections shall be to evaluate whether rental housing complies with RSA 48A14, all applicable building health and life safety codes, and the Tilton zoning ordinance. Next paragraph. The Board of Selectmen or its designated agents shall cause each rental unit to be inspected once every 3 years. However, periodic inspections may be conducted at any time as deemed necessary by the Board of Selectmen or its designated agents in response to complaints, observations, or other concerns. I'll just mention, I can't remember exactly how I saw something about shall permit the town's periodic inspection of the structure in which the rental unit is located. The wording there, I pulled that wording elsewhere, and my reasoning was that I thought it was important, in my discussions with Al, the code enforcement officer, and maybe with Tim, I can't remember, you have a rental unit, and then you have the infrastructure, maybe some of the maybe the furnace or something or whatever, some of the infrastructure that unit depends upon located elsewhere in the building outside of the rental unit. So I felt it was important to say the entire structure is open for inspection. So that's why that's there.
Should we say every owner of a rental property again?
That's what I was wondering.
I don't know.
That's a
No.
confusing part between unit and property.
I don't, I don't like to
Yes.
I don't wanna let go of rental unit. I like, I feel like it's important to send the message that every single unit is, being treated as its own unit. Maybe I'm just, I don't know.
Maybe residential rental, well, we need to describe a rental unit. Or define it, I mean.
I think
Rental
you said
units,
it's-
rental units shall include any property which contains a suite of one or more rooms located within a
Right.
single building. So we do have it defined within a single building rented by, it says, in common for residential, for non-transient residential purposes, yeah. I think we're good as far as
Okay.
defining rental unit. I don't know whether, I guess my,
I'm okay with
I'm good with it,
that.
yeah.
Yeah.
And then leaving it,
I'm good with everything on that one. Sorry.
Yep.
it's okay. Jenny's all right? To leave it, all right?
Yeah, I have
on a
to.
notice of inspection too.
All right, read that
Are
one.
we gone to that one?
No, I haven't read that quite yet. We are flying through here. Notice of inspection, except where emergency conditions exist, I think I threw that in on my own. Notice of the inspection of any rental unit shall be mailed to the owner 10 days prior to the scheduled inspection at the address provided on the registration affidavit. The owner shall be responsible for informing tenants of scheduled inspections. Should the owner refuse entry to the town may seek an administrative search warrant.
You're gonna need to define emergency.
What if the tenant
Really?
refuses?
It can't be just what a reasonable person would deem an emergency? No?
Some people are reasonable and some aren't.
Reasonable people are reasonable.
Define reasonable.
I know a lot of unreasonable people.
So, I mean, it's really catch-22, I think, when you go in, except when emergency conditions exist. So emergency conditions are, you get a
Immediate
complaint, and
Threatening.
something's there, and it's,
Or unless a life-threatening condition.
but you have that already under RSA 48A.
Yeah, it's pretty subjective, and I think a lot of it's
It is
underneath the
subjective.
designee of the enforcement, so,
Right.
I mean, if you thought
Right.
somebody was cooking meth and you smelled it, would that be
Yes.
covered under other things?
I
Or
You
think
wouldn't
so,
have to
but-
worry about
but
that, because
I
a
think-
911 call would be just sufficient
Right,
to be.
well, I think that comes into play in a lot of these. When there's an emergency condition in existence, there's probably gonna be a lot of other forces at play and a lot of other RSAs and, regulations that come into play that wind up being a lot more, maybe even more relevant than this. So
Actually, an emergency condition would be a 911 call, really. Any of them.
I think going off what Tim said, it's elsewhere. It's sort of put in the hands of the official. Is that sort of what I was
Yeah,
kind of
that's kind
gathering?
of, and I think it's mentioned in a couple other of the paragraphs that are written, that, because it's subjective from the inspector. It may be one or two things that are adding up to one huge thing that you can't clearly define. So there is some, it's really, like Dar said, is in the hands of the inspector. For me, it's personally, I can't define it, but if it's something that needs to be rectified immediately, like there's no, okay, we can wait till tomorrow,
Right.
that is an emergency condition.
What's that word they say? Imminent? Imminent?
I mean, yeah,
Could we? I mean, what if we?
Imminent danger.
Except where emergency conditions exist representing an imminent
No,
danger.
because now you're limiting yourself.
Okay. So
Yeah.
let's-
Because an
all right.
emergency condition
All
could
right.
exist
Without
without imminent danger,
Okay.
yet it would be, it could propose it could, not propose, but it could end up being a catastrophic event.
Okay. Right. Imminent means basically about to happen, whereas what you're saying is it shouldn't go that. There should be also a good chance it's gonna happen.
Yeah.
Yeah. So should we leave it for now? And
Yeah, I
not-
think we can leave it for now and see if something
Alright.
else pops up.
All right.
What about the end, should the owner refuse entry to the town? What about, should the tenant refuse entry? What if it's the tenant that's refusing the
Oh.
entry?
I
So
don't
that's
know, good
one,
point.
one
A
more
lot of
little-
tenants feel
you know-
like they have that right. Cause they can
That's
refuse
what-
entry to the landlord.
Right, well, that's where I'm saying,
Yeah,
so
I think
you
you're
may
right.
need to address it so it's balanced.
Mhm.
And so, you know, there's.
The
this
tenant
is-
doesn't have that though. If the landlord is notified, they need to give 24-hour notice to the tenant
Mhm.
to say, you know what, the town's coming in to inspect tomorrow. I've given them permission. Then they don't have the right to refuse.
But they don't know that.
Right, well, that's what I'm saying, so it
Mhm.
just
A
have
lot of
something
tenants
in
would think they
here.
do have that right. And they would
Correct.
get pretty upset about it.
And it-
Maybe
There's a
hostile.
sentence that's saying specifically owner refusing, but it,
Mm.
I guess that's where I just feel like it's just one of those things that
What if,
comes across as one-sided, so just
okay,
trying to,
Good catch.
I see where you're
Yeah.
going with that, but if you put that in, then you leave room for the tenant, given an idea for the tenant to refuse.
I mean, we technically can't go in
and I
and
think they're
and inspect
those kind
until,
of people are gonna do it that anyway, though, I mean.
until notification's been made to the
Already
property
basic
owner anyways. You know, the way that it works right now is if you make notification to the property owner and give adequate time, if the tenant doesn't want to open up or leave, then that becomes more of a, you know, a legal matter with the police. Then it's between the relationship between the fire department and the owner.
so you're thinking, in response to what Jenny said, I was thinking, let's just simply say, should the owner or, and then add, or tenant refuse entry to the town may seek an administrative search warrant.
We
But-
can't seek an administrative search warrant against a tenant. We can as an owner. We can't as a tenant though. That it won't go anywhere. We can only do that to the owner. The relation, if the tenant says, no, I'm not letting him in,
Not fair.
that relationship is between the tenant and the landlord, not the tenant, not the tenant and us.
So should there be another follow-up sentence that says, should the tenant or anyone else refuse entry to the town? Or is that just, we don't want to necessarily go there in this ordinance? I mean, there are avenues that can be,
I think if, in my opinion, I could be wrong, if a tenant doesn't want to allow us in and the property owner has communicated and done everything that they're required to do, then it's a legal matter between the tenant and the property owner. It doesn't really have anything to do with us at that point in time. The property owner's trying to comply with everything that's here, has done everything they're supposed to do, and so really now it's just a matter of the local authority, police.
Police, right.
So can we
involvement.
say, instead of saying, should the owner refuse entry to the town, can we say, should entry be refused to the town may seek administrative search warrant?
Well, we wouldn't do an
That
administrative
would,
search warrant.
that's really not saying anybody, it's just saying.
It's, no, but it's,
refused.
if I don't get in, there's gonna be a problem, yeah.
right, you have to say owner because you can't issue one to the tenant at all. Now, if the tenant were to create some type of disturbance or things to the police, then that would bring up a whole nother thing. But there's no way that we could, if I called up my tenant and said, hey, Ted, the inspectors are coming on Tuesday next week, and they're coming at noon, and you need to let them in, is that a reasonable time for you folks, or you know, because you have to understand that they work nights or something like that, and it's, you can call back to the health office and say, you know, they really can't do noon, but could you do 3, make that a reasonable request. They get there and they don't open up. That is nothing to do with the tenant. The health officer now would come to me as a landlord, and I have to deal with that. It's not anything, they can't cite them for it, they can't do anything for it. It's all legally bounded by the landlord because they're the owner of the building. And the landlord is the one that can be there and open that door and let them in, regardless of what the tenant says or not. But it's really between the landlord and the tenant at that point.
So as long as the landlord has a key and they properly notified the tenant, they can just open the door? The landlord can just open the door to the town?
If it's duly noted, yes.
Okay, as long as it's,
It's
noted,
right,
even
if
though
they've
the
gone
tenant's,
through the
like,
whole-
kind of,
Right, and you've
upfront
notified and you have record
Okay,
that you've
that's- I just wanna make
notified
sure
them,
that they can.
they can do that, yeah, you can do that, within a reasonable, like, I know I have to give them 24 hours before I can, unless there's an emergency and then they say, yeah, okay, unless they say, yeah, can you come over here and take a look at this? If I say, geez, I have to come in and look at the water heater and I make sure about something on it, I have to give them 24-hour notice.
Right, right. But
So if
just
I were
wanna-
called by
I guess
that-
I'm just trying to avoid, I don't know, tenants that are gonna be pains in the butts.
So,
And there's gonna be
Yeah.
lots of them too.
so if the landlord has done everything that if the property owner, landlord, has done everything they're supposed to legally do, and they have the master key to get in, and everybody knows that on this day they're coming to
They
do
can go in.
inspections, and that landlord knocks on the door, landlord, we're here for the inspection, and that person is in there, but is refusing to let them in, that's when it's like, that relationship between the tenant and the landlord comes into effect, and then it's on them at that point in
Right.
time.
Then the landlord-tenant relationship has to kick in, and you have to know your rules and regulations around that, and your rights, whether or not you can say, no, I don't want him to come in today. Sorry, things have changed, and, I'm drunk or naked or whatever, it doesn't matter.
Tenants have too much,
I know,
How
isn't it?
many
It's like,
it's just so
that's where
frustrating.
loopholes are. People
But it's
find
the
loopholes.
laws, and I understand that, I just find it frustrating, as, the tenants. are
You
just
find
like,
it
"No."
frustrating, I think they
No.
find it frustrating.
Well,
I just,
come at, from a landlord and a tenant kind of perspective, so, I just find the one-sided rights of the tenant frustrating.
So I was a tenant for 30 years, and I've only been a landlord for 3. So I'm seeing the other side of that right now,
Mhm.
and you kind of know that there's something going on over there, but you can't put your finger on it. And I always give them, as long as I give them a notice and say I'm coming in at such and such a time to fix this, they can say to me, geez, my daughter is sick, can you come to another time? I can say, well, it's not convenient for me, and then still go, or I can say, well, yeah, that works for me. You don't want to ruin that relationship either, because,
Right,
it depends
then
on...
you might not get
Well,
your
it
rent.
depends whether you want to rue it or not.
Yeah, yeah.
But particularly, I don't know how that would work with, I think it would be more difficult with out-of-state landlords, because now you gotta phone them and you
I
gotta
guess
say,
Yeah, part of what I was thinking, like, well, what if it's the tenant that's refusing
Mhm.
entry and the landlord has nothing to do with it, and they're not around, then what?
right,
So I just
Right.
trying to keep it so that it's,
yeah. Or the
Across the board.
landlord is the one that, or the landlord created a designee,
Correct.
and the designee is refusing, now it becomes even
Yeah.
more
Correct.
stickier.
so should we put that into, should the owner or its designee refuse entry to the town?
I think you should put that in, Gary, because we have
Yeah.
landlord,
Your
Which
property
is it says
managers.
owner.
property
Yeah.
managements, yeah, and owner or designee,
Yeah, I think designated.
yeah,
That's a very good point.
because then it becomes their problem, but we can look further into, Jenny does have a good point in that, but I'm not really sure where the law stands on that.
Yeah, it's tough, it's tough.
I added something that I think kind of gets at sort of what our discussion has been saying. The owner, and then I added or his designee. And I can put her or her if you want.
Or designate.
What's that?
So the owner
Or
or
designee.
designee.
shall be responsible for informing tenants of scheduled inspections, and then I added, and for providing physical access to all rooms and spaces within the rental unit, or,
I think it's a very good point, Dar. You run into it a lot of times where a tenant will change keys or keys have been swapped out and the property owner uses that as an excuse not to get into a specific place.
Right.
okay.
That does, I know that that happens with Catherine and a lot. You can't get in because they don't have the key. The landlord, he's in Massachusetts, and it's, you know, it might be the utility room. They can't figure it out.
Yeah, right, okay.
So when we send the notice 10 days prior, should we send it to both the owner and the designee?
No.
Mm-mm.
Uh,
Oh, designee, yes.
Well,
Yeah.
Especially if they're out of state.
let's
Or
look
if
at,
they're
I think
not
we need
local.
to make sure that works with the affidavit, because I think the affidavit basically is getting at that. It's saying.
The
this
affidavit
in-state
tells us
person-
we go to the designee,
Yeah.
so,
Mm-hmm.
All right.
so we would send it to the designee.
I think a perfect example is like Lockmere Meadows.
Ah, that's perfect, yeah.
You know, everything is Hodges. That they do everything. You
Yep.
know.
Right.
I, for one, appreciate all the work and effort you put into this, Derry.
Oh,
It's very
thanks.
well
Yeah.
done.
Oh, thank you. Yeah, it
Oh,
was,
yeah.
obviously,
Very
it,
good.
it was mostly done by the 4 towns that we
Yeah.
borrowed stuff from,
Well,
but,
but you had to cut and paste and,
yeah, right.
and look at it
No,
and
it took
figure
some
which
work.
one.
Yeah,
It's
no.
not easy.
No, I mean, you know, I felt like it had to be something that represented our meetings at this point, so yeah, it was kind of fun, actually.
Did you change the one, should the owner or designee represent you to the town? Did
Yeah,
that
I
last
think you did.
sentence?
Should the owner
Or-
designee refer?
Should the owner or
last sentence.
designee, yeah.
Oh.
You're gonna resend this out to us, right?
Yeah. Okay, we actually have now one more piece, right? Well, a few more, actually.
What format was that in that you sent out? Because mine went to a PDF file, which I think is very hard to read.
I think I sent it as a PDF.
Oh,
Yeah.
okay.
Which is usually, you know, the most universally.
I know it is.
But-
But my computer says ouch.
Minimum standards. So this is completely, you know, just taken. The minimum standards, the following substandard conditions for rental units shall not occur within the town of Tilton. This is the I'm not gonna read all 10 of them. This is the RSA. So, if we wanna take pause at some point to read those, we can, but I'll just keep going for now. Then go down after number 10. Additionally, the following shall be required of each rental unit within the town of Tilton. Now this I took from, what was it? Starts with an E.
Exeter?
Exeter?
Mhm.
Okay. Exeter. And that was what we had agreed upon. What we talked about, so there's that. Just, you know, we talked about in our previous meetings, maybe using this as a starting point and then referencing the National Healthy Housing Standards and then a HUD checklist that we have at our disposal. Somebody sent it to me, who was it? Anyway, we have the,
See, I don't agree with, I gotta back up here, because such facilities above described shall not be shared by more than 6 persons living therein, except members of the same family, in a single-family dwelling unit.
where is that one?
Under
Sanitary
sanitary facilities.
How many branches are we including in the family tree? Too, you know?
Well, there's mom and her boyfriend and his kid
That
and
sort of
her
seems-
kid.
it kind
and-
of seems to,
We're
you
all
know, kind of
brothers
like,
and
well,
sisters.
then people are
So
gonna
if-
try to be exempt from it.
So if you're looking at a rental unit, case B, I have 3 different people renting my unit. Okay,
Mm-hmm.
so what happens if, you know, their brother or sister come and, or whatever, So now they come for a week or 2 weeks or whatever. And what happens then? I have 3 separate people not connected to family that rent, that are on the lease. So I think that if I have that situation, that there's got to be some other people. Well, I have a 3-bedroom home.
Well, the
Are
Golden
you talking about
Girls had
them
that.
having visitors?
Sure.
No, I'm talking about living in the home. So prior to the tenant that I had 5 living in the home. What I'm saying is,
Something happened, yeah.
if you had 3 separate parents and a couple of kids, it could go up to 7, or could go up to 8.
This, don't forget, this is only saying a bath, they're saying a bathroom, they're not talking about the entire unit.
I know they're saying the bathroom,
Okay,
but
okay.
why are we
It's like-
limiting it? Are there rules and regulations
I don't know.
to 1 bathroom per so many people in a house?
That may be on the health side, it's not on the life safety side, but there
Where
is
did
this.
you get it?
What was it again?
Epping?
Exeter.
Exeter.
Exeter?
But I think what you're referring to more than anything is, so you have that situation where you have additional 2 people for a month, or, 2 or 3 months because of whatever situations. So would it just be as easy as such facilities above described shall not be shared by more than 6 persons on a consistent basis? I mean, because I view that as temporary more than
Are there
permanent.
other people out there that have more than 6 in their apartment, though? That's my question.
Oh,
So that's my question, and only have 1 bathroom. So,
yes.
Something to
there,
look into.
and so then this wouldn't work.
Yeah.
So then they would not be able to be in the apartment. I mean, I'm just thinking in terms of what we have out there now
Right.
for apartments. Are there other landlords out there that have more than 6 tenants in 1 apartment building, 1
I don't
apartment?
know of any laws about the bathrooms, it's the bedrooms, isn't it?
So
Under
if
law,
we,
don't you have to have a certain amount of bedrooms, then you're
So
fine?
a certain amount of people
so
per
if
bedroom.
we put this through, then we're saying,
Yeah.
Wait,
I
you
see what
think
you're
there are
saying.
rental units in Tilton where there are more than 6 unrelated people sharing the same bathroom? I doubt it.
Oh, I didn't see the unrelated part. Did it say unrelated?
I know,
here?
that was
Yeah,
gonna be my
except
next
members of
one.
the same family.
'Cause
so
I
that there's
think-
an
It could be
exception.
I think there could be.
I think it could be. I
I don't
had
know.
5 in mine, Dari, last year, my tenants. There were 5 people. 3 adults and 2
But were they
teenagers.
related?
No,
None of them?
none of them were related.
I think that's extremely rare. What about just getting rid of that entire last sentence?
I'm just saying that if I have it, I'm on a committee that's putting this together. If I had it pretty close to the 6, would other people have it in a
they
4-bedroom or a 5-bedroom
Yeah.
home?
Yeah, I think we're thinking of just like those 1-bedroom situations with the 1 bath, but you could have a rental unit that has 2 to 3 bedrooms, and just think of a single-family home. A 3-bedroom house with 1
Just
bathroom.
seems weird that they'd have 1 bathroom, but yeah. I mean, I've never, like, the zoning ordinance doesn't talk about related and unrelated, and,
No,
some
they
towns
don't.
do get into it. Tilton doesn't seem to, so maybe there's no need to get into
Well,
it
and there's
here.
always
Take
the case
whole
of
thing about the number of
And
people.
who the hell am
Friends
I to
renting
say
an
that I can't
apartment
share a
together.
bathroom unless I'm related? I mean,
I-
seriously.
Yeah.
Yeah, I mean, I don't know. Sharing a bathroom with 6 other people that I'm not related to, though, I mean.
You might want to have 6 girlfriends over, and then
Well,
and they're not
that's
going to be
true.
related. Then what the hell's going to happen?
Here's a good example. So we have the tech, obviously, and down towards the Winnisquam end and Lockmere end, a lot of kids rent those properties
Mhm. That's
for the
right.
semester. So you could have
Yeah.
4 or 5 students renting,
One
a
apartment.
single apartment, like when you were in college.
Yeah.
We had 3 bathrooms.
Yeah, well.
But whatever, yeah,
But
I
not
don't.
all of them do.
Yeah, I mean, I hear I'm arguing for some. I mean, I'm really not arguing for it. Why don't we go like this?
Yeah.
Yeah,
Does that,
there you
does that
go.
work?
So and there's other codes that
That's a really good compromise.
that can come into effect if they're overpopulating that rental unit.
Yeah,
that would really meet, I
Right.
think, the intention of
Yeah.
what
yeah,
it's
yeah, I
going
agree.
after.
Right. Okay, so
What was that?
we took that out.
Okay.
I was just saying, there's other guidelines or codes that can be enforced for the increased amount of population in a rental property.
Oh, right.
So if
right.
that's really what that's trying to do, I know I don't know about the sanitary thing, that's more of a health thing. But I know in
Right.
life safety, there are specific things about the occupancy levels of rental properties.
Well, that's why I asked if you got it out of a code or
Yeah.
something. Because if it is, then we need to have it put back in, but if it's not, I mean, let's.
All right.
I don't think there would be
I've
any
only
code
ever
that says you have to all
heard
be
of
family
bedrooms.
members.
I've only ever heard that you have to have a certain amount of.
Catherine might
Bedrooms
maybe have an
per-
answer to that, I'm not sure.
Well, it might be it might depend on whether you're in the town water system or if you have a septic system too.
All right.
Well, that's the whole bedroom.
Yeah,
I've got it crossed out, so,
Right.
but still sitting there.
Sitting
so,
there, okay,
yeah,
good.
Yeah.
All right, food preparation and refuge. Contains kitchen and cooking. Okay.
So lodging, dwelling or lodging unit, because we're not including inns and bed and breakfasts and lodging.
Oh,
To me, kind of.
excellent.
yeah,
Yeah.
yeah.
Pick up.
How about a winter rental unit? Winter rental unit.
Rental unit, right.
Yeah.
Space and security is fine.
Do you want me to be reading these?
yeah, I like space and security too.
Christ, I'm in trouble with structure and materials.
What does that mean, really? The rental unit shall afford the occupants adequate space and security. Well, what's adequate space
Hmm.
Well, that's a good
by
point.
definition? I mean, then we're going into the whole occupancy and,
It's very subjective, what's adequate space.
right, some people like to have a little studio apartment and other people,
Mhm.
well, you know what, I need room to stretch, so, I mean, I just think it's,
Shall
Very
afford
open.
the occupants adequate security.
I
Take space out of there.
I think that's probably aiming
yeah.
at trying to get or minimize overpopulating of units again,
Mhm.
just a different way.
Okay.
But it's so,
Just,
it's so vague,
subjective.
it's almost, is it worth having that? 'Cause
Sometimes having something vague in there, though, it gives you something to grab onto in those rare cases.
A little wiggle room.
Yeah,
Mhm.
Yeah.
yeah.
I don't think people would have a hard time or find that real disagreeable to read.
Yeah.
I feel like, yeah, the only time you'd probably be able to sort of lean on this as a code enforcer would be when it's blatant, you know, and in that case, maybe it's good to have it there.
Yeah.
It's a good point, though, it's definitely
No, I agree.
Okay. Are we okay with structure and material?
I haven't gotten through
Because I'm not okay with interior air quality.
I just think the first sentence is all that's needed under structure and materials.
Oh. And would you like to see everything gone, or do you just feel it's not?
I just think it's kind of, one sentence sums up everything below. I mean,
Mhm.
and there's going to be other things as well that might affect the structure and the safety of the building that's not going to be listed in here, so.
I wonder if Al and Catherine, though, would like that additional guidance, not for them, but for the,
As a landlord, I wouldn't like it.
all right.
Just saying. As a selectman, I would.
Or,
I mean, I have a 160, 70-year-old house.
Well,
can we take
yeah.
oh, we're gonna take it all out.
Well, I've got
All
it
of
crossed
those-
out
Yeah,
now.
and yours, a wall may
At the very least,
bulge a little bit,
that word
but
ether,
it's built,
The word what?
ether.
you know,
Right.
at a huge beams probably that, you
Right.
know.
Grammatically, you don't really need, because I think
But
it's
the
supposed to be
old
either,
fussy
but
on
you don't
plastic,
need it
it
grammatically.
cracks.
You
Yeah.
don't need the word
So
anyway.
it says
But if
cracks
you get rid
here.
of it, doesn't matter.
I just,
Right,
That's supposed
and
to be
cracks
other.
is part of a lot of houses,
Oh, others,
especially the
yes.
old
Yeah.
plaster walls.
Right.
Change that.
Alright, I'm a grammar
Where- what did you just say?
All right.
My family hates it, trust me.
All right, now we're on interior air quality.
Well, I mean, do we all agree? I crossed this all out.
Just-
All right.
But leave it there because we
Okay.
really want to find out about that.
Yeah, all right.
All right, now I have a problem with interior air quality. I have a problem with dust. The rental unit shall be free from dangerous levels of air pollution from carbon monoxide, sewer gas, fuel gas, dust, and other harmful air pollutants. I have no control over my tenants with dust. Please do not cite me for that.
Huh.
Mm-hmm.
It ain't happening.
The rental
I got enough in my own house.
But
What?
do you not want an inspection of your house that, or your rental property that uncovers that your tenants are allowing massive amounts of dust to accumulate? Would you not want
I
that
don't want to be
identified?
cited for it.
Well, if
And
you've
you
got
would
30
be.
days to fix it, during that 30 days, you might be able to.
And so what if they don't? Should I be charged for them?
Well,
No.
you're right, and this is something that I had brought up before, I'm like, you know, so what if it's tenant caused?
Yeah.
You go in,
Yep.
you have 30 days, as landlord, you say, please do this. And the tenant still refuses, then what? Then does the recourse that we're gonna file, do whatever to the landlord, then fall onto the tenant? Because it's supposed to be a standard, it's supposed to be for both the tenants
So-
and the landlords, but can we legally do that?
So let's say he goes,
Can't.
let's say he dusts the day after you leave, and they say, okay. And then 30 days you go back and check it,
Yeah.
we're in trouble again.
Alright. So do we all agree dust should go?
Yes.
I think with that, it's really looking at is to make sure that there's adequate ventilation, like
Yeah.
the windows.
Oh,
work,
that's
that
what I
there's-
was thinking.
Right, and I think
I
that,
love the
and I,
last sentence.
and I agree with, you know, all the fuel
First,
gas,
last
the
two.
harmful air pollutants, the
Mold. instead of-
monoxide, everything like
Mold
that.
would be a good one to add instead of dust.
Yeah, instead of dust, mold, because that's an actual health, that's an actual hazard. What is it?
So should I put mold?
Yeah,
Yes.
Alright. Alright.
instead of dust.
Or, yeah.
Well, mold is a really big issue.
Yeah, because
Well-
I gotta tell you, Catherine has had a few calls that have not been able to do anything about it, and there's been mold, and there's been, you know, and very difficult.
It can be hard, it can be almost impossible to get rid of it,
Mm-hmm.
but it can make you very sick too.
Yeah.
Yeah.
Yep.
So, in practicality, if these, if violations are discovered and there's a 30-day or a longer period granted, and the owner is seeing that the tenant is not, doing their part in terms of correcting the violation, do you guys think this will result in, what do you call it?
Eviction.
Evictions, yeah.
Well, that's what I was asking before.
Over a period of time, if you can show cause, yes.
Yeah. And maybe that's almost a help to tenant, owners then, to give them.
I'd like to see that happen
Mhm.
as a little bit of.
I think a
help to
lot
have
of people
because
would.
It's hard for landlords, so if we can legally give them a little bit of a help
Yeah.
with these tenants that are causing real damage to their properties, you know.
Yeah, right. It seems to me, right, so this ordinance is actually, in that sense, it's a big help to the owners, because it helps them identify, yeah.
I think they'll see it that way too.
Correct, yeah,
Yeah.
and I, you know, and I just wanna make sure the wording in these things does
Mhm.
allow the landlords to read it and identify that, okay, this could help me too, not
Mhm.
just,
Not
all
just be,
about
oh,
me
this is
having
gonna
to
be
do all
costing
this
me a
stuff.
fortune.
Right,
yeah.
right. It's like when you have to tell, yeah, when you have to tell, like, if you have to tell an let's say you're a manager at a store and you have to tell your workers that they need to do something, it's a lot easier when you say, well, the big store manager told me I have to tell you guys to do this. Anyway.
And it's really for your benefit that you do this because,
Mhm.
and not just feel like they're being, you know,
Mhm.
like it's all about them having to uphold all these things. So they react well to it and they'll register happily.
And nobody complains.
Yeah.
And maybe Pat won't
We're
get
just
100
coming
phone
up on
calls.
8:30, and I didn't know if we
Alright.
wanted to try to push through this, or do
Why
we
don't
wanna
we
table?
just, yeah, we've got a few
Yeah.
paragraphs left,
I know.
so let's just finish up and then do the minutes and head out.
Perfect.
Does that work for
Yeah,
everyone?
works
All right,
for me.
thank you for getting us back up. So water supply, the rental unit, or sorry, I'll just read them, let's go through it. Water supply, the rental unit shall be served by an approved public or private sanitary water supply free of contamination.
Yep,
Makes me
sounds
wonder.
good.
Oh, sanitary, is sewage covered in the top one or no?
Yep.
Okay, lead-based paint, if a rental unit presents a hazard from chipping, peeling, or loose lead-based paint, all such surfaces shall be cleaned so as to remove all chipping, peeling, or loose paint, and the surfaces so clean shall be given at least 2 coats of suitable non-leaded paint. Entrances and exits, every rental unit shall have a safe, unobstructed means of exit to a safe and open space at ground level. Entrance and exit to a rental unit and passage thereto shall not lead through any other dwelling unit or through a space that might reasonably be locked by anyone who is not a member of the household.
I did highlight that, and I don't know, it's a little different on the life safety side of things. You have your entrances, you have your exits, you also have escapes. So, one of the things that we run into quite a bit during rental property inspections is that every bedroom has to have 2 means of escape, one being the doorway to get out, and the other's usually be a window, and a window's gotta be a certain size. And we run into that quite a bit, where they're too small, or they're a replacement window that don't meet the size requirements. So I don't know if that should be included here, because that's one of those big ones when we come to an
Yeah.
inspection.
That's it.
And obviously, another component is height from escape to the ground. So if you're above 20 feet, you're required to have a fire escape if you're using that. So I don't know if we just want to put entrances, exit, and escapes.
Oh, okay.
And I can just come up with some wording that
So
include,
entrance, exits, and escapes.
if that works.
Excellent.
From a rental, to/from.
Well, I think what we'll do is we'll we'll maybe cross this out with the knowledge that Tim is going to work on a more suitable language for that. Does that
Yeah.
work? All right.
I agree with them because there has been some
Yeah.
instances.
Oh.
And fire escape should be part of it too.
Do the ladders count as a fire escape?
Yeah, there's specific codes on fire escapes. Pretty much as long as it's a structurally sound application, and it's so many feet from the ground to the building, you're all set. But there's a bunch of them that aren't compliant right now that are out there. Some of them you actually see are just like a landing with no ladder coming down, and that's just an area of refuge, which sometimes is allowed. But anything over 20 feet definitely has to have some sort of way out of the.
So if you have a second floor,
that's above 20 feet, then you need to have something out there.
something of some type of a landing?
So you can have there's a couple of different ways around it. There are certain occasions where a means of refuge or area of refuge, a lot of people use it, is out there with the understanding that the fire department will come throw a ladder up to get you out, or use the ladder truck to get you out. Then you have others where the unit might have 3 or 4 stories, or it might have more than what we're able to reach, or it may need to have something that comes directly down to the ground. It really depends on how the building's set up, though.
So anything over 20 feet.
It is required to have
And
something.
what
like
about
that.
those interior things that people put over the window and those ladder? Do you know what
Yeah,
I'm talking
that's
about?
that's not
For those?
that's an emergency use.
Yeah.
So you really need to have something in place. Yeah, it doesn't really meet the intent of the code.
Well, that's what I was wondering.
Yeah, it's more for a residential,
Yeah.
single family.
What do you do in cases of people renting, like maybe the in-law apartment or something like that, in a basement, and they have just one of those little bitty?
Yeah, so that would be
things, what do you
allowed,
do?
unless the building was sprinkled. It wouldn't be allowed. And I know we run into it quite a bit, and people are like, oh.
So how would we fix that? Like, so let it, they've got a lease, and these people are renting there, and then you come in and you say, sorry, and they can't maybe structurally put a bigger window in or afford it or something, then what happened with that? Does the tenant get kicked out?
Technically, by the state of New Hampshire and the law, they're not supposed to be renting it out because of
Right.
that.
Or if they put a sprinkler system in.
Interesting. I don't
It happens.
know of that situation, but
I've run into it.
sure it's got to.
I've run into it. People don't like me when because a lot because of that reason.
Yeah.
That's an expensive one.
Yeah.
All right, so you're gonna come up with
Yes.
something different.
Okay.
All right.
Fees
So we're in the
and
home
fines.
stretch here, and if you guys need to leave, we can obviously stop, but anyway, I'll keep going. Fees and fines, there shall be no fee for routine inspection. If an inspection reveals violations, the owner will be given, shall be given, but anyway, 30 days or some other reasonable period of time established by the Board of Selectmen or its designated agents within which to demonstrate that the violations have been resolved. In establishing a time frame, this is, I added in my own, in establishing a time frame for resolution other than 30 days, the Board of Selectmen or its designated agents must not allow unhealthy or potentially unsafe conditions to persist unreasonably.
Should we put, like, sometimes, I don't know how many times you've had to deal with it, but I certainly know that carpenters aren't always the most dependable people for showing up.
I think we have
Can
to,
you
That's
put
within
I
a
don't think that should be in the
reasonable time.
ordinance.
Well, that's what I was thinking, should you put down, like, that they're either fixed or in the process, or,
No, that gives too much leeway. This, what my thought is that, Al,
Goes on an
Tim,
individual
and
basis,
Catherine are
right.
all very good at working with people, they know how to work within the ordinance, but also be reasonable
Yeah.
and give the citizens,
Yeah.
that they serve some reasonable opportunity to get things done, with an understanding that things happen, people get sick, people don't show up.
Should it be said though, because we talked about that at the last meeting, that you can kind of determine that if the landlord's making efforts, But also, in establishing a time for resolution other than 30 days, must not allow unhealthy potential. So can it be expanded upon to say that some conditions may warrant a period of shorter than 30 days that are,
yeah,
need to
cleaning
be,
the
what I'm,
gardens.
like, just put it in there that maybe, and it's up
Mhm.
to the inspectors, it could be less than 30 if it's a threat that needs to be resolved.
It does say that. I didn't, and good point. I recall now that I intentionally didn't write 30 days or some law extended. It does say the owner shall be given 30 days or some other reasonable period of time.
I like the wording.
So that could be less than 30 days.
So
Can
we
we say
had,
more than or less than?
well, usually it's less than, there are some times that it is less than when we had an apartment complex using their parking area for trash.
Right.
I mean, really bad trash for years.
I just wanna make sure that they
Trash.
know that, cause
Well-
sometimes they might read this and go, okay, 30 days, or other, they're just gonna automatically think more than.
Would
They
you?
might not think less
Yeah.
than.
They probably will, but it doesn't matter because it's a reasonable
But
period
we
of
can put,
time.
30 days or other reasonable, and just put maybe in parentheses, less or more days or something, just to make it a
I
little
think
more
you should
clear.
just take or some other reasonable period of time out, because you already have the intent. The
Mm.
owner shall be given 30 days established by the Board of Selectmen or its designated agents within which to demonstrate the violations have been resolved. In establishing a time frame for resolution other than 30 days, the Board of Selectmen or its designated agents must not allow unhealthy or potential unsafe conditions to permit unreasonably.
It
Certainly
doesn't
implies
quite
that it
work.
does.
Wait,
Yeah.
because most of that paragraph applies to the other reasonable period of time. So if we pull out the other reasonable period of time, it doesn't quite make sense. But I kind of feel I like it the way, I really like it the way it is. I
think it describes it in that second sentence, what you're trying to
Yeah.
achieve.
I do too.
Yeah. Well,
I think it's good.
sometimes when you hear people read it again and, yeah.
yeah.
I always try to read something and say, now, what are they gonna find a loophole with?
That's
Well, I think-
was my thought, so I'm like, I just want to make sure that they're not gonna go, it says I have 30 days,
Here comes the
I have 30.
loophole.
You know?
As I read, I said, there's no good reason for someone to assume that the other reasonable period of time is more than 30 days. However,
That's how people think.
yeah, maybe, yeah, right.
It is how
But
people
you're
think.
always thinking about reasonable people, though.
I
Well,
know.
I'm always just going, okay, what are the unreasonable
There's a
people?
lot of unreasonable people
Gonna
out
think.
there.
Yeah, well, I think you write your ordinance trying to cover everybody, but then you have to accept the fact that at some point, reasonability
Yeah.
has to come into play. But yeah. There shall be no fee for routine inspection. If inspection reveals violations, the owner shall be given 30 days or some other reasonable period of time established by the. We could say, or some other reasonable period of time greater or lesser than 30 days, but it shouldn't be necessary to put.
It's redundant to say,
Yeah.
I agree it's
Yeah.
redundant, but I'm like,
Yeah.
ugh, sometimes people need redundancy just to make it clear, but
How about this? We leave it as it is now, and if in our in the upcoming months, if we
Sleep
keep
on it, yeah.
discovering that all right.
And I do think that the people who objected to the original proposal at the town meeting were landlords more than tenants.
Oh,
And I
yeah.
think that we have 2 test cases coming up with public hearings, so I mean, that's gonna be our test.
Mm-hmm.
We're gonna get their,
We'll get
say,
their
this is our,
feedback.
we're gonna get feedback. If they object to reasonable period of time, then you're on point,
Mm-hmm.
Right.
Jenny.
Yeah,
You know what I'm saying?
yeah.
If they say, well, what does this mean? Then you're gonna know that they're
need
looking
that
for a
clarification.
loophole. Right.
yeah.
So you kinda can gauge that. So the violations period
He
being
reacted
established by the
into
Board of
preemptive.
Selectmen designated agent shall be subject to fines established by the Board of Selectmen. Yeah,
Okay. I definitely
right.
Let's not get into that. A meeting without discussion about fees and fines is pretty amazing. Never thought that would happen.
Mhm.
No, well, we did discuss some fines though, fees, I mean.
Appeals.
Yeah.
Any person aggrieved by any action taken pursuant to the implementation of this ordinance may appeal to the Board of Selectmen.
I like that too.
All right.
Good way to end it.
All right, so I will send out what we've done. Obviously, we were very landlord light at this meeting, so I think it definitely is going to benefit us as a group to recognize that at our next meeting, there may be some things that feel like a step backwards to some of us, but that's how it needs to be.
Do we want to use next meeting as a revision and then at least establish a public hearing at that
We do
point?
need
Because
to
we'll
set
be
up
in
a
So,
August.
so at the next
Yeah.
meeting, we'll decide when we're gonna have our public hearing, is that what you're saying?
I
Yeah,
think that's
I'm fine
good.
with that.
Yeah.
I
Sometime.
think we're almost there.
By some September, October.
Yeah.
Alright.
And then, because you have to have 2 before January.
Okay, yeah,
So-
yeah. And the longer we can have between them, probably the more time the better.
Mhm.
So that we can do any
So we can
kind
fix
of.
whatever they talk about the first one.
Exactly, exactly.
Okay.
And take up their points and then get ready and then do a final public hearing and then a final submit to the Board of Selectmen for the warrant.
Oh, yeah,
Mhm.
I mean, that's our charge.
yeah.
So
All right.
Next
So will we meet in another month, or 2 weeks, or 3 weeks,
Month.
or?
August.
I mean,
Okay.
I
Yeah.
stay on our schedule. Okay, so minutes from last time?
As long as we don't have the public hearing, I mean, if we had it towards the latter part of September, that would be great, because I'm having knee surgery at the end of August, so not sure I'm gonna be here for the September regular
Oh, okay,
meeting.
all right.
I may miss that one, depends.
If we did one like either that or even like the first week in October,
Mhm.
that would give us enough time to do the first week in December as well, because public, get it, you know, before Christmas time gets too close. That'll give us our two, plus we'll have a couple of meetings to hash out, you know, to get things, then we'll get that hearing in, then we'll have a little more time to even go back to our drawing board, and then still get another hearing in
Right.
before the, you know, holiday craziness and people actually show up,
Right.
you know?
Hmm.
I don't, rough.
I agree.
Rough. Okay.
All right, minutes.
Minutes, so we have the June 7th draft meeting minutes before you. Any?
Do you have copies or?
Yeah, I got a copy. Anyone else need a copy?
I'm all set, all right.
Okay.
Mr. Joubert.
Now I make this sound all official.
Jeez. Minstrel.
Whenever, if anyone has taken a look and feels ready to make a motion, obviously we'll accept one whenever folks are ready. Motion to deny the minutes. And I assume this is saved properly.
I'm going to make a motion. Are we ready to make a motion or not?
What does
Whatever
it
you
mean,
want.
what does it mean that, the last paragraph that, Chairman Sasan agreed, saying that the board, as the board starts to develop an ordinance that is ready to begin sharing, meetings should be publicized beyond the minimum legal requirements, develop an ordinance that incorporates stakeholder input, and to ensure that the board is not blindsided its public
No,
hearings.
at or during its public hearings, it should be.
Okay. That makes sense.
Thank you.
Okay, now you can make it.
Okay.
Yes, correct.
I move that we accept the meeting notes from last month's, as, with corrections, or as corrected.
All right.
I'll second that.
All right. Any discussion? All in favor?
Aye.
Opposed? All right, motion carries. Anything else folks want to discuss before we accept the motion to adjourn?
No.
All right.
Motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
Thank you, guys.
Thank you for all your hard work, Gary.
Yes,
Thank
thank you,
you.
My
guys.
pleasure. Thank you,
Very.
guys.
We got that, you know.
I knew that was what you were gonna say.
You know what?
That's perfect.
That's gonna be the first thing he looks up tomorrow. You don't know him, Jenny. That'll be the first thing he looks up.
sticking with you.
I
Cannot wait to send Jenny that
Yes.
email.
tell my family to watch the video because they're gonna go, yep, there she is.
Where, where do they find it? I have looked for it. What channel's it on?
Correcting people constantly.
It's on the website.
Oh, on the website.
Do you work up at Spalding?
I used to.
Oh, you used to? Okay.